Hi guys, this is part 1 of our introduction to fundamental rights, one of the most questioned topic in CLAT and other law entrance exams, and one of the most important topic to be understood. So in this introductory session, we will discuss as to what are fundamental rights, why do we at all need fundamental rights, where did the idea of fundamental rights come from, and where in the Indian Constitution are these fundamental rights mentioned. We'll discuss how did the Constituent Assembly go about bringing these fundamental rights to our Constitution. We'll also discuss how are these fundamental rights enforceable. And in the end of this lecture, we will discuss the first kind of fundamental right which is enshrined in the Constitution, which is right to equality. Now, fundamental rights are those rights which are guaranteed to citizens and some other people to protect the liberties which are granted to us by the Constitution. Now, why do we need fundamental rights? The first reason I already told you, to protect our liberties. The second reason is to ensure that there is no unreasonable encroachment by the state authorities on our fundamental rights. So there is no decision or no step taken by any of the authorities, public authorities I mean, to encroach upon our liberties. Fundamental rights make sure that there is no such encroachment. Now, where did this idea come from? So the fundamental rights are called Magna Carta of the Indian Constitution. Now, what is Magna Carta? So Magna Carta was the first written document which had rights related to citizens. It was released in 1215. It was the first written document related to fundamental rights. Now, how did the fundamental rights come to the Indian Constitution? So we know that there are a lot of provisions in the Indian Constitution that are borrowed from various countries. Fundamental rights is also one such provision which is borrowed from the United States of America. So United States of America has this long list of rights called the Bill of Rights. So the fundamental rights in the Indian Constitution have been borrowed from the United States of America. Now, when the Constituent Assembly was deliberating over the fundamental rights inclusion in the Constitution, they had made a separate committee for this. This committee was called the Advisory Committee on Fundamental Rights, which was headed by Sardar Vallabhbhai Patel. Now, after the Constitution was finally enforced on 26th January 1950, there were 7 fundamental rights in our Constitution initially. So there were 7 of these fundamental rights. However, in 1978, right to property, which was mentioned in Article 31 of the Constitution, was scrapped from the fundamental rights list, and it was made a constitutional right under Article 300A of the Constitution of India. Now you must be wondering as to what is the difference between a fundamental right and a constitutional right. So fundamental rights are rights which are at a higher pedestal than any other constitutional rights. So fundamental rights are those rights against which no law can be enforceable. So if there is a law passed by any state government or the central government which are violative of the fundamental rights, then such law does not sustain. However, there are certain exemptions that are given to the legislature to pass laws, and those laws in the interest of general public can transgress constitutional rights. So we have 6 fundamental rights which are enshrined in the Constitution of India, starting from Article 12 to Article 35. So now we need to understand as to how these fundamental rights are enforceable. So can anybody enforce fundamental rights, or can it be enforced against any authority or against any individual? No. Fundamental rights are always and only enforceable against the state. Now, what is state? So the definition of state is given in Article 12 of the Constitution of India. So we need to understand the basic definition of state here. It means the central government and the parliament, basically the central government, the state government, the local authorities which are created, for example, panchayat, municipal corporation, municipalities and so on, and any other authority which is under the central government. So these are the basic examples of the state authorities against which fundamental rights are enforceable. I cannot enforce my fundamental rights against an individual or a private authority. These are only enforceable against a state authority. Now let's move on to the first kind of fundamental right, that is mentioned in the Constitution of India. So Article 14 to Article 18 talks about right to equality, which is the first kind of fundamental right. Now, Article 14 states that the state shall not deny any person equal protection of law and equality before law. Now, we need to understand some concepts here. It says that the state shall not deny any person. So, any person here does not mean only citizens of India. Article 14 is hereby applicable to any person within the territory of India. It could be a resident, it could be a foreigner, it could be citizens, it could be any person within the territory of India on which Article 14 is applicable. Now it says it should ensure equal protection of law and equality before law. Now, what is equal protection of law? So, equal protection of law is a positive connotation that is taken from the United States of America. Now, what is equal protection of law means is that equals must be treated equally. This is enshrined in the Constitution of India. What does this mean? So, we see that there are tax slabs on our salary, right? This is one of the examples that I'm trying to give you. That there are tax slabs. For example, say I earn 20 lakhs per month or 20 lakhs per annum. Per month is too much an amount. 20 lakhs per annum, and the tax slab that I'll fall under is 30%, right? Whereas there's a person who earns 4 lakh per annum, and the slab that he's going to fall under is a lot low that I fall under. So now this, I may say that this is discriminatory because we are not rendered right to equality here. But this is not discriminatory, and such discrimination is allowed in the Constitution because we are not equals here. Okay, I am earning 20 lakhs, the other person is earning 4 lakhs. So that person is at a lower pedestal economically, and the Constitution will not recognize these persons from the perspective of taxation as equals. So the Constitution of India provides that equals must be treated equally. So for example, there is another person who is earning 20 lakhs and I am also earning 20 lakhs. So if that person is treated differently, for example, that person is brought in 10% tax category and I am brought in 30% tax category, then that kind of a provision is violative of the Constitution because that is discriminating between the equals. I hope you understood the difference in what is equal protection of law. Now, the other important concept to be understood in Article 14 is equality before law. So, equality before law has been taken from the United Kingdom. It has some sort of a negative connotation. It means that no person is above law and law is equal for all. Basically, all the persons are equal in the eyes of law. Now, what does this mean? It means that I as an individual is equal in the eye of law than to Prime Minister. So I and the Prime Minister of the country are equal in the eyes of law. There is no difference. Every individual is equal in the eyes of law. That is what it means. So we see that Lady Justice standing in every court blindfolded. हम बॉलीवुड मूवीज में हमने उन्हें अंधा कानून का नाम दे दिया है, but it actually means that law does not discriminate between anybody. So that is what Article 14 is all about. Now let's move on to Article 15. Article 15 states that the state shall not discriminate between the citizens on the basis of race, sex, color, caste, creed, place of birth, and so on. Now, an important point to be noted in this, that Article 15 only mentions citizens and not everybody. So Article 15 is only applicable to the citizens. So it basically states that in usage of public parks, public buildings, wells, pilgrimage places, so these are certain places where the state cannot discriminate on these certain bases, which is race, caste, sex, and so on. So the state cannot discriminate on this basis. However, there is an exception given that the state can make certain laws for the upliftment of women, children, and certain lower classes of society, basically certain backward classes of the society. State can make laws for their upliftment under Article 15 of the Constitution. Now, Article 16 of the Constitution states that in public employment, the state shall not differentiate between anybody on the basis of race, sex, caste, place of birth, and so on. So the first one was respect to usage of public buildings, public parks, wells, and so on. Now, this is with respect to the public employment. So, in public employment, the state shall not discriminate between citizens. Now, this provision is also applicable only to the citizens of the country, as it mentions citizens. Now, there's a qualification here. If the state feels that there are certain kind of reservations required in public employment for the upliftment of certain socially and economically backward classes, then state can have some sort of reservations. We see that there are certain communities in India who are provided reservations in public employment and in promotion as well. So that is enshrined under Article 16 of the Constitution, and it is constitutionally valid. Now we move on to Article 17. Article 17 prohibits untouchability. It states that any practice of untouchability within the territory of India is prohibited and is punishable. So there are certain laws which are enacted by the state legislatures as well as the central government to prohibit any form of untouchability within the territory of India, and is a protection required under the fundamental rights of the Constitution of India. Now, the last part that we discuss for today is Article 18 of the Constitution. So, Article 18 abolishes use of any title by any person. So, earlier during the British era, there were certain titles given to persons such as a zamindar, a peshwa, and so on. There were certain titles like these which are given to people. Now, nobody under the Indian Constitution can use such titles in front of their name. For example, my name is Keshav Malpani. I cannot use a title Peshwa Keshav Malpani in front of my name because that is not constitutionally valid. I hope you guys understood the lecture. You guys understood what are these fundamental rights, why do we need them, and right to equality. If there are any doubts, you can always write to us on our mail ID, which is mentioned in the description. If you like our sessions, please subscribe to our channel and press the bell icon so that you don't miss any updates from us.